Live from Westlake Village, California. You can check out anytime you like, but you can't never leave. Rando Liberal.
Baby, don't you know the fix is in? This court was made for sin.
Today, in our first segment of The Fix is In, crony capitalism descends upon the White House.
Contrast that with what's going on right now with the Trump administration in Washington, D.C. I'll show you. They just opened up a club just a couple of miles from where I'm standing. It's called the Executive Branch. This is a club that Donald Trump Jr. just opened up, and someone can pay $500,000 to get into this club with guaranteed access to Trump administration cabinet members and officials. That is gross. That is gross, and it's people buying their way into the administration, and Americans deserve better.
Ask not what we can do for the country. Ask only, how much can you pay for us to do what you want us to do for your country?
Hit 'em up, move 'em on, hit 'em up, right, cut 'em out, right 'em in, cut 'em out, right 'em in.
It's fugly. So the big activity last week came in the cases arising out of the administration's extraordinary renditions of people who are primarily, but not exclusively, Venezuelan nationals to a notorious El Salvador prison with truly horrific conditions. The renditions arise out of the president's Alien Enemies Act proclamation, which declared that the Tren de Aragua gang was operating as a foreign state or foreign nation and engaged in an invasion or predatory incursion against the United States.
Two cases arising out of these summary expulsions came to a head in this past week. The first is a case that originated before Judge Boasberg in the D.C. District Court, and that's the challenge to the lawfulness of the administration's implementation and use of the AEA. That's the case where Judge Boasberg issued a temporary restraining order against the administration's use of the proclamation. Mr. Abrego Garcia's lawyer challenged his deportation, and a district judge, Judge Zenas in the District of Maryland, ordered the administration to try to bring Mr. Abrego Garcia back. And the Supreme Court initially issued an administrative stay, deferring the district court's initial deadline to return Mr. Abrego Garcia to the country. The court took some time to dispose of the application after that initial administrative stay, and it ultimately denied the government's request to put the entire order on hold. So it left in place a directive for the government to, quote, facilitate Mr. Abrego Garcia's return.
Did not rule on the lawfulness of the administration's invocation of the Alien Enemies Act. That is, didn't say whether the law can be applied to Tren de Aragua, which is not a foreign state, nor did it really rule on the administration's implementation of the AEA. That is, whether the administration can even send people to a foreign prison rather than deport them to their country of origin.
The court said, for example, quote, the government expressly agrees that Tren de Aragua members subject to the removal under the Alien Enemies Act get judicial review, end quote. So that is suggestive, but it's not definitive.
Also, please note that none of the people put on the two planes to El Salvador got any fucking judicial review. And the Supreme Court wrote its order, I think, intentionally that way. But it could be devastating.
In brief, the Supreme Court left in place the lower court order to the extent it directed the government to, quote unquote, facilitate Mr. Abrego Garcia's return to the United States. We're literally playing Wordle over a man's life. We're all left wondering, what does it mean to facilitate? What does it mean to effectuate? What's the difference? And since the justices invented this distinction that gives the executive branch considerable wiggle room to weasel around whether or not they have to bring Mr. Abrego Garcia back, it's not really a settlement at all.
And what say you, Chief Justice John Roberts?
What's the sort of criteria that you use for deciding whether you want to take a case?
We're not a court of error in the sense that we correct mistakes. So what we're looking for are conflicting decisions on the same law that have to be fixed. I mean, if one person reads this law and says you can't do this, and the other person says, no, it means you can't do this, it should mean the same thing across the country. And so that's more the type of case we would take to resolve that disagreement.
Ah, yes. So you say potato, I say potato. Or if you say Facilitate, I say.
You could get him back. There's a phone on this desk.
I could.
In an interview with ABC News, President Donald Trump said he could bring Kilmar Armando Abrego Garcia back from El Salvador, but he won't.
You could pick it up, and with all the power of the presidency, you could call up the president of El Salvador and say, send him back right now.
And if he were the gentleman that you say he is, I would do that.
But the court has ordered you to facilitate that.
I'm not the one making this decision. We have lawyers that don't want to do this.
But the buck stops in this office.
No. I follow the law.
Trump's comments contradict what his top aides have said about the U.S. not having the ability to return Abrego Garcia. Despite the Supreme Court's ruling that Trump must, quote, facilitate his return, administration officials said they can't because Abrego Garcia is in the custody of a foreign country. Trump officials admitted in court that the Maryland man was wrongly deported because of an administrative error.
Even given those numbers that you're talking about, don't you need to uphold the Constitution of the United States as president?
I don't know. I have to respond by saying again, I have brilliant lawyers that work for me, and they are going to obviously follow what the Supreme Court said. What you said is not what I heard the Supreme Court said. They have a different interpretation.
Is anyone in your administration right now in contact with El Salvador about returning Abrego Garcia to the United States?
I don't know. You'd have to ask the Attorney General that question.
Yes. Attorney General Pambandi, what do you say?
They're deranged is all I can think of. I cannot believe, I think some of these judges think they are beyond and above the law, and they are not. And we're sending a very strong message today. If you are harboring a fugitive, we don't care who you are. If you are helping hide one, if you are giving a TDA member guns, anyone who is illegally in this country, we will come after you and we will prosecute you. We will find you.
That seems ridiculous. So Abrego Garcia's lawyer also told Rachel Maddow that the sealed delay request did exactly that. It said that the U.S. Department of Justice needed time to take steps to return Abrego Garcia to the United States.
So their lawyers confirmed.
That's right. But the day before the delay was going to expire, the government filed another motion under seal, and this time the judge denied it and ordered the discovery process to resume.
Yeah, fool me once.
Mm-hmm.
Right? This is what her order said. By no later than Friday, May 2nd, 2025, which was a couple of days ago, the plaintiffs, that's Abrego Garcia's lawyers, must narrow their interrogatories 9 through 11 and requests for production of documents 6 through 8, consistent with her other order that came out before the delay was granted. Now, also, she said defendants, that's the Trump administration, the government, shall answer and respond to all outstanding discovery requests and supplement their invocation of privileges consistent with the court's order. That means give me a log. And if you don't give me a privilege log, I'm taking away all of your privileges.
Exactly.
And she's asking for that no later than Monday, that's tomorrow, May 5th. The depositions of Robert Cerna, Evan Katz, Michael Kozak, and Joseph Mazzara, the 4 people that had, submitted affidavits, sworn declarations, they need to complete depositions no later than Friday, this coming Friday, May 9th. And by no later than this Wednesday, May 7th, the plaintiffs can move for leave of court to conduct up to 2 additional depositions of individuals with knowledge and authority to testify regarding the matters identified in her original, or not original order, but one of her many orders. And the defendants can respond to that by Thursday, the next day, May 8th. And that's where you and I, Andy, were like, they should get Kristi Noem in on the stand, or Marco Rubio or something.
Yeah, and for sure.
But this letter comes from 150 judges. Norm, tell us what the subject is and who some of these judges are.
Jen, the nation was shocked when Donald Trump, who's been assaulting the rule of law, took the next step, and last week went after one of the people in charge of defending rule of law, a judge. Who ever heard of a judge being arrested for controlling their courtroom? Today's letter was over 150. Actually, by the time we filed the letter, it was over 160. former federal and state judges from all over the country saying, what? We don't arrest judges in America. In a normal time, there would have been other ways to express disagreement. John Roberts just said to Donald Trump, your unusual ways of disagreeing with the judiciary, calling for judges to be impeached. No, we file appeals. We file complaints. We don't arrest judges. So these judges were outraged. It was a bipartisan effort. It was led by one of our most distinguished former Republican-appointed federal judges, Judge Michael Ludig of the Fourth Circuit, one of our most distinguished Democratic former appointed judges. That would be Judge Nancy Gertner of the Federal District Court in Boston, Massachusetts, and their colleagues. And bipartisan, was supported by us at Democracy Defenders Fund and also by the conservative Society for the Rule of Law Institute.
Katie, have you ever heard of former judges who tend to be entirely apolitical, entirely content to let their colleagues handle this? Have you ever seen or remember something of this magnitude?
No, I haven't. And I know that the adjective unprecedented has been used and abused a lot in both Trump administrations, but it's important to emphasize how spectacular it is to see people from ostensibly, quote, both sides of the aisle in terms of appointments come together to be able to tell Trump to shove it. And it's critical for people to understand that
That's a legal term.
It's one of the most powerful ones. The best judges, you don't know what their politics are, and you shouldn't know what their politics are, because judges are supposed to call balls and strikes as they see them based upon the applicable law. In this instance, to see a letter that has compelling language in it calling out the Trump administration for perp walking a judge for purposes of embarrassment and for intimidation, you don't see this ever. And so I think people need to be reminded, Jen and Norm, judges are human beings. They carry their own biases, their own prejudices. They leave them at the door when they put their robes on and they take the bench. So to have a coalition of judges that say, you know what, it's worth the risk, because remember, there's physical threats of harm that are being made to judges that stand up to Trump and the administration right now. So these judges that are willing to put their names on a letter that criticizes this administration and calls it out for its illegal conduct is a very big deal.
Absolutely. And Norm, some of the language that they use is very compelling because this really isn't about one judge. It's about an effort to chill, to intimidate the other judges who are on Trump's cases or are on cases that could hear his decisions. How important is it to kind of lay down the marker and let him know that the judiciary as a whole is united on this?
I don't remember the last time I've seen the names of more than 20 judges. You know, you get en banc opinions sometimes. You get a couple dozen signatures on that at the most. If that, you get a Supreme Court opinion, 9-0, like when they denounced Trump for denying habeas corpus to immigrants. But to get over 160 judges to sign on to a letter condemning, Jen, I was there as Ludig and Gertner were working out the text of this letter, and it was so strong. And they said, gosh, will anybody sign on? And they said to each other, well, this is how we feel. We're going to put it out in the world. We're going to see what happens. To get 160 judges condemning, and they wrote Pam Bondi. That is the beginning of a powerful new coalition. It's the first time we've seen judges move like this. Donald Trump is trying new things. He lost so much. He's trying these outrageous criminal moves now. So we're seeing new forms of defending democracy.
And before we go on to our next item, I want to emphasize what Norm just said. This is a letter to Pam Bondi.
Yes.
Because it's not the actions of individual ICE agents, just like it's not the individual actions of some poor assistant U.S. attorney who goes into court. Now, I know they have a legal ethical obligation to play it straight in court and to not misrepresent and not mislead the courts. But ultimately, this is Pam Bondi, who sat in that hearing room and told lawyers and told the country and told judges and told the Senate she was not going to politicize the judiciary. And now that it's happening, it's exactly right. You have to lay it back on her doorstep so that everyone knows who is ultimately responsible for that. Okay.
And I think, very quickly before we move on, very quickly, I think the really important collateral impact of this is basically telling the Supreme Court, look, we're watching. We're watching this. Judges talk to other judges. This is a coalition. This is a group of state and federal judges. And regardless if they're retired or former, they're still talking to their brethren, their colleagues that are still on the bench. I also think the Supreme Court is paying attention to this because the Supreme Court also noted that any type of intimidation of a judge is not appropriate. This type of, fear tactic that they're trying to implement is not important. And so we have to hope that the Supreme Court does the right thing, especially coming up on May 15th when they hear some important nationwide injunction arguments on the 5th.
Exactly. And that's such an important point, Katie. When conservative justices weigh in and people that they know personally, like Harvey Wilkerson from the Fourth Circuit, they do listen, they do pay attention. All right, let's go on to one of two lawsuits that dropped within the hour, and one of them just minutes ago. But you have a front row seat, so you will be among the first to know. The first lawsuit brought by an attorney, Mark Zaid, who represents whistleblowers, people with national security items. He has a national security clearance that allows him to do his job. But Trump doesn't like certain lawyers. We've seen that. We've seen that with the law firms. And so what do? They yanked Mark Zaid's security clearance. Well, he has now turned around and sued. And he got a little bit of a boost, I imagine, on Friday from Beryl Howell.
Exactly.
Norm, tell us the party.
I think Katie wants to tell you.
You got to
go on.
No, you do it, Norm. Your name is on that. Your name is on this.
It's another one. Every single person broadcasting or tuning in was a part of this litigation. Since we're owned by nobody, the profits go to support our Democracy Defenders Fund. Each and every one of you is a democracy defender. All right, Katie wants to jump in, so I'll be very efficient, Jen, because it is such an important case. You cannot take away the security clearance of anybody, but especially a working lawyer who represents national security professionals without due process. It's just like that Supreme Court case where Trump said the migrants don't have due process. And 9-0, the court said, yes, they do. How much more does an attorney who is barred in the United States, who needs his license, his security clearance, in order to represent his clients? That is protected by constitutional due process, a multitude of other rules. So Beryl Howell, one of the portions of the Perkins-Coie executive order that she struck down was the meritless revocation of Perkins-Coie security clearance eligibility for its lawyers. Building on that, Zaid and I and the superstar lawyer, lead counsel, Abby Lowe, God love him, Jen. He quit his law firm. He's also a friend of Katie's. All us trial lawyers, we're all friends. He quit his law firm with love and started a public interest law firm just to do cases like Mark Zaid.
Absolutely. And Norm, very briefly, Mark has sued the office of the president and also several agencies. What are the litigants in this, and why name those other agencies as well?
He's sued the national security establishment because they administer these security clearances. For example, Tulsi Gabbard, in a funny twist of fate, herself accused of maybe not the most sound security practice. She's going after the most respected national security lawyer in the country, who, by the way, theme of tonight, and then I'll pass to Katie, very bipartisan. Mark Zaid is known for being tough on Republican administrations, tough on Democratic administrations. He represents some of the most broad array of clients. He sued a broad array across what we call the the intelligence community, probably Tulsi Gabbard, ODNI, the Office of the Director of National Intelligence, the most prominent of those other defendants.
Very good. Katie, one thing that we have kind of come to expect from this Supreme Court is extreme deference on the national security realm towards the president. And in fact, we saw that in Trump 1 a lot. And frankly, when the laws, my word, we have E. Jean Carroll joining us.
I see her.
Hi, Jean. When we first saw that law firms were beginning to challenge these retaliatory executive orders, some of them didn't even raise the security issue because that was thought to be a little too far because the president has discretion, the court showed deference. But Mark is saying, no, you don't get to hide behind national security when there's no basis for national security. You're simply retaliating. This is a breakthrough, I think.
Yeah, because remember, the national security concept is one that's supposed to be highly deferential because it's the executive branch, right? You're supposed to be able to give deference for them to be able to decide these things when they're the president. But I love how Norm wove in the reality of that Judge Beryl Howell bench slap, as I call it, from Friday night. He made sure that she carved out a specific section to deal with the fact that the national security clearance issue was just a red herring. It had nothing to do with the true intent behind that executive order against Perkins Coie and the other law firms, which is political retribution, and which is why Mark Zaid's lawsuit's so important. He was one of 15 attorneys from a March 22nd presidential memorandum within which their security clearances were wholesale revoked for no valid reason. And to Norm's point, no due process was given. Think about this, ladies and gentlemen. If you were a person, a craftsman, for example, that needed to have a specific toolkit to be able to do your job, and one day somebody arbitrarily, because they didn't like what you said or how you looked, took away that toolkit and you weren't able to do your job, of course, you would seek some type of justice for it. And that's exactly what Mark is doing. But he is being led by incredible counsel that know that because all of this is just Trump being pissy and having his feelings hurt, that there's no valid legal reason to revoke their national security clearances.
This is critical because judges are not buying this national security holy water that Trump and frankly many other presidents like to dribble over their doings. We have seen judges in the immigration area reject a state secrets defense, which is a very extreme sort of position. We've seen them reject simply a wave of the arms, national security, political question is another way of framing this. But the bottom line is because Trump doesn't have the facts and doesn't have the law, Norm, judges are willing to pierce that screen, that fog of national security. And this, I think, may have implications in other arenas, wouldn't it?
Well, Jen, we've seen such a transformation in the climate and that fog being cleared away by the bright light of judicial scrutiny. Remember when we started the Contrarian run up a few days before the Trump taking office, that powerful sense of presidential momentum? You and I were confident that if Trump broke the law, that our system would be strong enough to stand up to him. Now different people count in different ways. I like the New York Times count myself. I went back and did the math, over 100 orders for the 100 days. And what we've seen is that Donald Trump's flood the zone approach, which we thought might overwhelm these judges, would they hold strong or would they capitulate like Jeff Bezos did, or some of the law firms? Or what that flood the zone has been met with an equally powerful and indeed greater surge of rule of law. And as a result, the judges are piercing through the normal presumption of presidential regularity. I think history will look back on John Roberts publicly repudiating Donald Trump saying we don't impeach judges we disagree with. We have appeals. And of course, that matters because Trump continues to make noise. Just yesterday, he said, does the Constitution apply to me? Do I have to give due process? So I think we're seeing powerful judicial pushback. I'm so proud of my friend Mark, and of course, so honored to be a part of that legal team. And so delighted that Miss Fang over here, one of the great trial lawyers, has jumped into the fray, joining us on the Contrarian and also joining Democracy Defenders.
And remember
litigation.
what Howell did in a summary judgment case. That means it's on
it's
the
amazing.
merits. No set of facts could possibly make any difference. She ruled that that sort of precedent, that sort of provision is unconstitutional. If clients, if lawyers come back to the district that she sits in, which is the DC district, exactly where Mark Zaid has filed, that is really the only precedent that exists so far that this is illegitimate. So it's not only the merits of where he filed, but where he filed. And you can see, folks, the strategy behind this, one block after another, methodical, well thought out, and it's incredibly impressive. Norm's laughing because he knows exactly what I'm
I wish you could see the team meetings where the sausage is made. I don't know.
Norm's little, yes, you can see the wheels of justice and the wheels of
I've worked on, at this point, I've worked in one form or another. I've filed them, I've advised on them, I've represented witnesses in more than 60 of those cases that have been filed. Let me tell you, getting them on file, that's an adventure. But look at that Mark Zaid complaint, my friends. We're very proud of it. And Jen, I think that brings us to the third and biggest.
Exactly. And this is the AmeriCorps kids. AmeriCorps, of course, is this program that has had bipartisan support for decades. It allows young people to go into communities to help with education, healthcare, the elderly, environmental issues. Trump and his overlord, Elon Musk, decided they don't like this. Government helping people, that's not what they think government
God
is for.
forbid.
So they yanked it. They unilaterally dispensed with it. And all of these kids who have signed up to work for their country, to work for their communities, are out. So what did they do? Today, they filed a big hunking lawsuit. And Norm, not only them, but many community groups that enjoy the services they provide, plus their labor union. Tell us the grounds for this, where we have looked to in other cases for precedent, and lastly, how you have solved, I think, what we call the standing problem, meaning do you have the right litigants in the case?
The AmeriCorps case represents a coast-to-coast effort by every different kind of plaintiff. The kids who work there, the different community programs, the different kinds of community programs, the different grant recipients, the labor union that represents the people who work at AmeriCorps. We really took the time to cover the waterfront on these cuts. Like in all these cases, the government says, well, we didn't totally eliminated, but they've functionally gutted AmeriCorps. And Jen, let me just take a moment on why that matters, because it goes to what we call the standing issue, the issue of injury. AmeriCorps every year helps millions and millions of people, children in after-school programs, conservation programs for farmers and hunters and hikers, our senior citizens, and our working parents in healthcare programs. This is the core American spirit of Americans reaching out to and helping each other, government doing its part to get it organized. But really, it's community groups and individuals like the AmeriCorps participants who also joined our action. And the lawsuit says that devastation is sufficient standing. It creates injury to our plaintiffs
bring the suit.
that allows us to go to court and to bring the suit.
Absolutely. And I see in the chats here, we have people who were former AmeriCorps
It's amazing.
participants. If you have a story, put it in the chat, put it in the notes. We love these stories because let's face it, Americans need to see faces. Due process, it's important, but it's abstract. Here you have, and you will have the faces, the people, the stories, the biographies here. Katie, looking back at this from a political standpoint, isn't this toxic for Republicans? Why would they support this kind of really devastation on people who are volunteering for their country? Isn't this what Republicans are supposed to be about? Communities and people, not big government programs. How are they going to defend this?
Yeah, so I'm going to read the one line that is on the AmeriCorps website, at least what's left of it, right? It says, our mission to improve lives, strengthen communities, and foster civic engagement through service and volunteering. Clear and concise. What don't you see there? Ladies and gentlemen, you don't see just for Democrats. They're not improving just Democrats' lives. They're improving all Americans' lives. And Norm says millions of people have been impacted. Just in the chat alone, I saw people saying, I was in the AmeriCorps, my son is serving, my family. I mean, everybody has been impacted in small ways and large by AmeriCorps. You know, in the law, we have this idea that you can act or you can fail to act. Sometimes the outcome is exactly the same, right? So in this instance, the GOP, by failing to stop what has been happening with Doge and the Trump administration, is acting. You don't have to have the GOP affirmatively pick up a shovel or a pickaxe to democracy. The fact that they sit there silent and they don't say anything is proof positive that they know what's happening, but they're acquiescing to it happening. And so it's important for people to know that these lawsuits peel away the layers of bullshit so that people can see the true intentions behind why this is happening, which oftentimes with Doge, there's no real good reason, let alone a legal reason. And that's why these lawsuits are important. These are nonpartisan lawsuits. These are lawsuits that are brought to expose the hypocrisy of the actions that are being taken by this administration. And when you have a judge enter a temporary injunction or restraining order, or a judge says, you know what, this is not happening on my watch, then you know that there is justice that is being realized.
And Norm, we have seen a number of cases, you've been involved in some of them, in which these unilateral cuts have been enjoined by courts. You've had success with that theory because, of course, Congress has the power of the purse. How does this case fit into those others? And are the precedents that you're developing in those other cases going to help the AmeriCorps kids here?
I think so. And Katie makes such a good point because the MAGA caucuses in the House and in the Senate have abandoned their constitutional responsibilities.
Yeah.
Hi, this is Joe, your host on Rando Liberal. I'm going to drop my announcer voice here for a second and insert a little bit of a shameless self-promotion of my own Doge suit. Some of you may not know or may know I'm not a lawyer, but I have been filing cases in the federal court to try to push back on some of the problems of our time, many of which we talk about here on this podcast. And I thought that would be a good opportunity to sort of bring up what I've been doing. I filed a case against Doge a few weeks ago that a presidential order that established Doge established it as a temporary agency to advise the president about how he can get rid of waste, fraud, and abuse, auditing the books of federal government. And, since then they've done quite a bit that has nothing to do with auditing books or trying to make things more efficient. It has more to do with just taking a wrecking ball to all the programs that they don't like. That's objectionable because these are all programs that were authorized by Congress, that only Congress can authorize funds. Only Congress can take those funds away. Here you've got a guy that's donated, $280 million plus to Donald Trump's campaign, now given this sort of authority of the king, wielding and saying, I can get rid of whatever I want to get rid of because the king said so. In the case that I filed, I asked the court to assign an independent special prosecutor because they're breaking the law. They're violating the Constitution. And I want court to do its duty now that, Congress has basically surrendered their authority The only guardrail left is the courts, and the courts have to look at this. Anyway, you can read about some of my other cases in my Substack feed, but I just wanted to say hello and hope to see you again soon. Rando Liberal!
Baby, don't you know the fix is in? This court was made for sin.